Federal appeals court struck down the dumbest copyright law, one that you probably didn't know about and one that you've probably violated. It's 17 U.S.C. 407, the mandatory deposit rule, which says that if you have created a copyrighted work or own it and you publish it, you have to send 2 best physical copies to the Copyright Office. And if you don't, the Copyright Office is authorized to fine you. Now, you may be familiar with the deposit requirement for copyright registration, but this is a separate statute. It applies even if you don't want or seek copyright registration. Again, not many people know about it, and people who do know about it memory hole it. In this case, Valancourt Books got a letter from the Copyright Office. They're a book publisher. And the letter said, for every book that you've published, we need you to send 2 physical copies to the Copyright Office. If you don't, we'll fine you $250. And if you don't comply again, we'll fine you $2,500. Not once, but for each copyrighted work they fail to send. So Valancourt Books to the Copyright Office to court, and they argued that this was unconstitutional. The district court did not agree that it was unconstitutional. They sided with the Copyright Office, so it was appealed to a federal court of appeals. 2 constitutional arguments were made. One, that it violates the Takings Clause of the Constitution, and the other, that it violates the First Amendment. The Takings Clause is the part of the Constitution that says the government cannot take your property without providing just compensation. Here is where the government says, well, you do get benefits from giving us the deposit copies. You get copyright protection. And the court said, no, that's wrong. And it most definitely is wrong. You don't get copyright protection from sending them the mandatory deposits because you get copyright protection automatically when you've created the work. That's in the Copyright Act. That's why we signed the Berne Convention Treaty and we have to follow it. There's no formalities required for copyright protection. Now, there are benefits you get from copyright registration, but you don't get them from the separate mandatory deposit rule. You don't get the statutory damages and attorney's fees for prevailing in a copyright infringement action. That comes from the copyright registration. You don't get the presumption of validity. That comes from copyright registration. And you don't get the right to sue. That comes from copyright registration. So all in all, you get no benefits. The copyright deposit requirement is for the benefit of the Copyright Office itself and not for you. And that's the reason that the District Court of Appeals found that the law is unconstitutional. It violates the Takings Clause. And because the court said you're seeking the same relief for the First Amendment violation, we're not going to reach the First Amendment issue at all. I think it ought to have reached the First Amendment issue, but it did not. My name is Mark Jaffe, Five Bridges Law, representing creatives in California and New York.